Good evening. My name is Matthew Brown, and my presentation is about employment law, specifically when looking at whether a worker should be classified as an employee or an independent contractor. For a brief overview, first we will look at how we define the terms employee and independent contractor. Next, we will look at the factors that the courts use to determine an employee status. We will also take a look at a current event involving a current company called Uber and the legal principles and issues involved with the Uber case. And then lastly, we will finish with a couple of discussion questions. So first, in determining employee status, we look at how the term employee is defined. Generally, an employee is somebody who's working part-time or full-time under a contract of employment. As an employee, they have the recognized rights and protections that are guaranteed through employment law. This has to do with Social Security, withholding taxes, unemployment compensation, workplace safety, employment discrimination, etc. They also recognize that their duty as an employee is to be an agent of their employer that they're working for. So by being an agent of an employer, that means that they are the person directly working with third-party people so that they are earning money for the employer. They're doing what the employer is asking them in relation to working with that third party. An independent contractor is a bit different. They're contracted to perform a task for someone or some company, but they aren't being controlled by that person. In fact, the hiring body has no right to control the contractor. Therefore, the contractor acts on their own accord. They perform the task how they see fit with no outside interference. Much like an employee is, the independent contractor can, or they may or may not be an agent. It depends on what their contracted role is. So they may be working with third parties for the employer, or they might not. It might be something else. It all depends on what they've been contracted for. Now, this can get kind of messy, but the courts do take a look at many factors when determining employment status. So one thing that they look at is the control of an employer. So does the employer control many different aspects of what the worker is doing? If they do, it's likely that it's an employee. If they don't, it's likely that that person is an independent contractor. Is there a distinct separation of the business or occupation of the worker? So are they doing something that's really not at all involved with what the employer's business is? If that's the case, then it's an independent contractor, most likely. Such as if they're in the business of sales, but they've contracted a plumber to do some work, that plumber is not going to be an employee for them. They are just independently contracted for a specific task. The level of direction or supervision, if there's a high level of supervision and there's many directions given by a supervisor, by a boss, it's most likely an employee. If there's not really any supervision taking place, not a lot of direction, there's no control over how the person is working, that leans towards independent contractor. Supplier of tools. If the worker has all their own tools, they're probably an independent contractor. If the employee is, or the worker is being given all of the tools by the person who's paying them, by the employer, they are probably an employee. The length of employment, basically long versus short. If you're employed for a very long time, it's likely that you're an employee. If it's a short time, or it's only for short periods of time, you're probably an independent contractor. Payment method, if you get paid upon job completion, that sounds like an independent contractor. If you actually have scheduled payments over certain time periods, that sounds like an employee. And as far as required skill level, if you're doing a job that really requires very little skill, it's likely that you are an employee of the employer, as opposed to an independent contractor who generally has a very large skill set that they're utilizing. So for the current event we're going to look at, deals with the company Uber, which is an online or mobile platform for driver services. This company provides an alternative to taxi cabs. Many people enjoy using services like Uber and Lyft just due to the ease of access, the ability to avoid having to use that taxi service. Uber currently finds itself in a situation which several other service on demand, as they call them, companies have been experiencing. Plaintiffs of companies like Uber, Lyft, Homejoy, Postmates, just to name a few, are claiming that they have been misclassified in regards to their employment status. In the case of Uber, drivers are arguing that they've been misclassified as independent contractors instead of employees. The drivers want to be reimbursed for expenses such as gas money and vehicle maintenance, and they're also hoping to challenge Uber's gratuity practice, which essentially is the fact that the company lets passengers know to not tip the drivers because they state that a gratuity is already included in the fee. But drivers are not receiving any of these tips, simply their regular compensation. They would like to change that. They would like to be receiving their tips. The case that has come to light is called Berwick versus Uber Technologies Incorporated. Uber Technologies felt that there really were no facts to back up this case, and they actually requested for a summary judgment to take place, meaning it would quickly be disposed of without trial, and this was actually denied. The judge actually felt that many of the facts did lean towards Uber drivers being classified as employees rather than independent contractors. On June 3rd, 2015, the California Labor Commissioner's Office actually sides with the drivers. Uber was arguing that they provided only administrative support, no directions are given, no supervision provided. They simply notify drivers and passengers, of each other so that they can, contract that transportation business. But they don't control hours or set any requirements. The labor commissioner was not faced by this argument, though, stating that Uber, who does claim to be a neutral platform not involved in an employment relationship, is involved in every aspect of the operation, from examining prospective drivers through background and DMV checks to collecting their personal banking and residence information. Without these drivers, Uber's business does not exist. Uber has appealed that, and on September 2nd, 2015, this was actually upgraded to a class action lawsuit, meaning that all drivers of Uber now had the ability to join as plaintiffs with a common legal claim. So the momentum is really building in favor of the drivers of Uber. Now, what legal principles and issues come along with this Uber case? Something I was really looking at was the common law test of employment. And when I looked at this, it really led to some very interesting results. If we look at the three categories of this common law test of employment as analyzed by the IRS, for tax purposes, they look at a behavioral category, financial category, and type of relationship category. And when we look at that to determine what the employment status is, you really get mixed information with Uber. In the behavioral category, we look at whether the company has control or has the right to control how the worker does their job. Really, with Uber, the answer is yes and no. Uber can't control what the driver does, but they can receive reports and stop using said driver. So essentially, they do control whether the driver stays on as a worker for Uber. In the financial category, we have to look at what aspects of the job are controlled by the payer. The drivers are paid like employees. They receive paychecks from Uber, but their expenses aren't reimbursed and nothing is supplied to the drivers. So really, all that's supplied to the drivers is, their paycheck, but also just the knowledge of where somebody is that needs to be picked up. There's no gas money. There's no payment for like car inspections or car repairs. So again, that's another category that could go either way. And then if we look at the type of relationship that we have, there are no benefits for Uber drivers, But the key aspect here for this section is the driver's work, being driving or transportation, is a key aspect of the business. And that, to me, is the key determining factor, for my opinion. If the driver's work, which again, driving, transporting, is key to the function of the business, then they should be classified as employees. Without the drivers of Uber, there is no Uber. There is no transportation business known as Uber because they have nobody doing the transportation. So they are employees in that aspect. And if the drivers win this case and are declared employees, then there's going to be all sorts of employment law details that must be worked through. Workers are going to be covered under anti-discrimination statutes, meaning drivers are going to have the capacity to sue if they feel that they are not being notified of possible pickups for any discriminatory purposes. Also, Uber is now going to be liable for drivers' actions, and this includes tort liability, and it could create problems for Uber with additional lawsuits now becoming a possibility. So we're seeing all the problems that this case could really have for Uber in the long run. We also see tax liabilities that are going to end up happening. Uber is going to be responsible for withholding income, Social Security, Medicare, unemployment taxes. This additional work may require additional payroll staff, which is going to be costly for Uber. Uber is also going to have to abide by wage and hour statutes, which means that they're going to have to monitor the hours worked. They're going to have to determine workday beginnings and endings, and they're also going to have to pay overtime premiums, ensure meal breaks and rest periods are being offered and taken. So there's a whole lot of different aspects that are going to take place that they have to follow through if these workers now become classified as employees. What I found really interesting about this, and it is what leads to my discussion questions here, is when you take a look at Uber's website, if you look at it like you want to be a driver, because you can go on and you can apply to be a driver, Uber plasters the fact that you can be an independent contractor all over their site. But if you start to read the fine print in their agreements, it really seems that even they're not convinced that they have independent contractors, because they have so much information in there about their liabilities and how they want to protect the company in case they want to protect the company, and also help the driver if something would happen. That's not something that a company would do for an independent contractor normally. They would want to stay completely separated, but they do seem to have established some sort of employee relationship. So I'm intrigued. I encourage you to go onto their website and kind of look over that information and tell me what you think about that, because I think it seems like although they really force feed independent contractor down your throat, it really seems like they've already agreed, pretty much made it clear that they think they are really employees. I don't know. It's very interesting. Another thing, how might the outcome of this case affect the other mobile businesses that count on these independent contractors to make money? There are so many other businesses out here that you can contact simply through an app on your phone that will hook you up with somebody to do things like drive you places. They'll deliver you food, do house cleaning, things like that. And all these people are considered independent contractors. But if this court case goes through, it's going to set a precedent for all of these other workers of these other companies to go, well, wait a second. I think that maybe I should be classified as an employee, and then I'll be getting all the benefits of becoming an employee, because now my business will have to abide by employment law. For example, there was one company that actually got shut down called HomeJoy. It was an on-demand home cleaning service company. They shut down, citing lawsuits from cleaners who were claiming that they were misclassified as independent contractors. And they decided that it was just going to be easier for them to close their doors because it was going to end up costing them too much money and become too much of a hassle for them to continue to operate. Um, but that's where I'll leave you on that. The main argument I have for this case, from what I've been reading, what I understand, is the fact that Uber's drivers' work, which is transportation, makes up such an important, really integral aspect of Uber's business. Without them, the business doesn't exist. That means they should be employees. So that is what I have for you. Here are my references that I used for this. Thank you very much.